2.8, the Judicial Branch. So we have a 3-level federal court system, and this includes the district courts, the circuit courts of appeals, and the Supreme Court. And these are all constitutional courts, so all judges are appointed by the president and confirmed by the Senate and serve for a lifetime. So, Article 3 in the Constitution. So, Article 3 in the Constitution talks about the court system. It also empowered Congress to create inferior courts, and all federal judges have a life term, but most of them retire or go on senior status at age 65, and some have been impeached and removed. And this life term thing, that means that they can work somewhat independently from the other branches, so they can't be removed due to ideology, which creates a consistency, and Congress can't necessarily use the power of the purse to leverage power over the judicial branch. Now, Supreme Court, their jurisdiction, they have original jurisdiction, and that's the authority to hear a case for the first time. And they have this over cases affecting ambassadors, public ministers, and where a state is considered a party, because that's concerning with interstate things. So if the state is a party, original jurisdiction to the Supreme Court. They also usually use appellate jurisdiction, so it acts as an appeals court. Treason is defined as levying war or giving aid or comfort to the enemy, and it's the only crime mentioned in the Constitution, and there have to be at least 2 witnesses to testify in open court in order for to convict. Also mentioned in Article 3 is the right to a jury trial. So a criminal defendant, they have the right to a jury trial, and it's seen as this citizen check on government action. Because now you have a bunch of normal citizens playing a part in the government and making sure that we're being fair. Now, Federalist number 78, they are writing in response to how the Anti-Federalists are concerned about this independent judiciary. And Brutus, Anti-Federalist, they were there's no check on it. But Hamilton, writing Federalist number 78, he was but there's judicial review. This is a good thing, because with this judicial review, we can examine acts of legislature to see if they fit the Constitution, and, they can serve a life term. As long as they're, acting good, then they can be judges. So he was this independent judiciary, it's fine. It's not a threat. And that's what he was writing about in Federalist number 78. Now, the 3-level system. This is what we were talking about earlier with these 3 different courts. On page 181, there's this nice little graph that you should probably take a look at. It's got some bullet-pointed details for you, and now we're going to get into some more stuff. So, the U.S. district courts. There are 94. There's at least 1 in each state. And these districts can have multiple courthouses with multiple federal district judges. And they are trial courts with original jurisdiction over federal cases. Here are some terms to make it make a little bit more sense. So a plaintiff is the party initiating the action. And then the defender, they are answering that claim. They're okay, you made this action against us. And so in a criminal trial, that means the government is the plaintiff. They are initiating the action. And in a civil trial, there's a citizen being the plaintiff. And they will bring a lawsuit, against somebody else. And injury, that you're arguing for, the injury can be physical, but it's usually financial. So, federal crimes are also dealt with in U.S. district courts, and those are crimes that violate the enumerated powers in the Constitution, Article 1, Section 8, so that's evading federal income taxes. Although most violent and overall crimes, those are tried in state courts, which is not what we're talking about right now. And Congress has outlawed some violent crime and interstate actions. So, U.S. attorneys. Each district has a U.S. attorney, which is appointed by the president, approved by the Senate, and they represent the federal government in the federal courts. They work under the Department of Justice, under the Attorney General. They're assisted by the FBI and all those other federal law enforcement agencies, and they're dealing with immigration crimes, drug offenses, and fraud. So they are representing the U.S. in these cases. Now, civil cases, civil disputes can be brought to court for business or personal conflict, and some plaintiffs will sue over these things called torts. Torts are civil wrongs that have damaged the plaintiff. Now, a lawsuit is when a plaintiff files a complaint. They have a little brief explaining the damage and why the defendant should be held liable for this complaint. And you have to prove the defendant's liability or negligence in it, and there has to be lots and lots of evidence in order for the court to award these damages. And most civil disputes, though, are handled in state courts. Disputes involving constitutional questions will also end up in the district courts, so a federal judge then determines the outcome, and sometimes if a large group of plaintiffs accuse the same party, they can file a class action lawsuit. So this class of people, they're taking action, that's how I remember it, and courts may issue an injunction, which is a court order making somebody act or refrain from acting to help fix the problem. Also, sometimes people will sue the government. So a citizen or a large group will do it sometimes. Technically, the U.S. operates under sovereign immunity, which is how the government is protected unless the government itself permits itself to be attacked. But it happens so much that the U.S. Court of Claims allows citizens to bring constitutional arguments before the courts. So you can sue government officials acting in a personal capacity. So if some U.S. official crashed into your car, you could sue them, but you couldn't sue a military government official for sending a loved one into battle and then they die. You're not allowed to do that one. Moving on to the U.S. Circuit Courts of Appeals, these are above the district courts, and Congress made them permanent to help with this increased caseload and stuff. They can shape the law. So how do we get there here? A losing party can appeal based on the concept of certiorari. Certiorari. This is Latin for to make more certain, because we're going to make more certain that either I'm right and the court is wrong, or the court is right and I'm wrong. You're going to make it more certain because you're getting a second opinion. So the appellant, the person appealing, has to offer a violation of the established law, procedure, or precedent that led to the incorrect verdict in a trial court. Basically, what that means, that was pretty much quoted from the book. So basically this is what the court did wrong that led to the wrong decision. And the Court of Appeals look and operate different than the trial courts because there's a panel of judges, no witness stand, no jury box, and they don't deal with these new facts, but they question the laws themselves. So the petitioner will appeal the case, and the respondent will then defend the lower court's ruling. A public hearing happens, lasts about an hour, and they don't declare guilty versus innocent for criminal matters. They usually don't change anything with civil lawsuits because they are more ruling on procedural matters, and periodically, though, they will establish new principles. Now, the Circuit Court of Appeals for DC, they handle the appeals of executive branch regulatory agencies and all of that stuff, people being fined or punished goes to the DC Circuit Court of Appeals. And because of this, and then the way it's become a feeder court for the Supreme Court, it might just be the second most important court. Okay, and we finally made it to the United States Supreme Court. Sorry, I keep trying to put this little piece of hair back, but I got a haircut, so it's short. They are at the very top of this hierarchy, and they will mostly hear case appeals from the circuit courts and the state Supreme Courts. There are 9 members, and they pick which appeals to accept. They sit on the bench, they listen to the attorney's oral arguments, they pose questions, engage in discussion with the litigants, and they consider their decisions for a while. So those are all activities that the justices do. And they will overturn about 70% of cases that they take. And once these cases are ruled on, it becomes the law of the land. So they'll decide on technicalities of constitutional law, and they have had lots of national and historic impacts. For example, Marbury v. Madison was the first case of judicial review. So basically, there was this new law that, shifted around all of this judicial court system things, and then there was, a new president, and with him, a new cabinet. So basically, Marbury was just made into a justice, and he's like, dude, where's my commission? And he started bugging the Supreme Court to make the Secretary of State, James Madison. He's like, you guys have to issue a writ of mandatus so that James Madison will give me my commission because I need my commission. Get me these documents. And the court was like, yeah, Madison, you need to give him his documents. You can't do that. But instead of issuing a writ of mandatus, which would basically force Madison to hand over the documents, they were like, this whole Judiciary Act thing, that's not right. Like, that part of it's unconstitutional. And that shows how the court got the power of judicial review to, like, check what the other branches were doing. Thank you, I hope this helped.